Well, the Federal Environment Department is investigating whether land clearing in the Northern Territory for cotton crops was unlawful. It sparked calls from senators for a wider probe. Legal experts say it points to lacking uniformity of land clearing regulation across states and territories. Joining us live is constitutional law expert with Charles Darwin University, Dr. Guzyal Hill. Appreciate your time. Thanks so much. What are the constitutional issues at play here as you see it?
Thank you very much. So exactly right. What we are talking about here is part of the bigger problem. So all jurisdictions and the whole of Australia is involved. Legislation protecting the environment is fragmented and inconsistent throughout Australia. Sometimes clearing native vegetation does not require approval, sometimes it does require approval, and that will depend on each state and territory. Why such inconsistency? Because the Australian Constitution does not directly allow the Commonwealth to legislate on matters relating to the environment. That is why we have a tapestry of law, including international obligations, Commonwealth legislation, and state and territory legislation. Even within the state and territory, land clearing can be regulated by different legislation or agencies. For example, in the Northern Territory, everything depends on whether the land is under a pastoral lease, unzoned, or zoned land. That is why the proper solution to this problem is by far not an intervention to the Northern Territory, because we had similar problem in Victoria approximately 8 months ago. The proper solution is a coordinated and harmonized approach to align and streamline legislation respectfully and cooperatively. So it should be probably initiated at the national cabinet level. We should have a long-term vision and be able to plan for centuries for land clearing. And that should be probably included in the national plan and expanding the role of National Environment Protection Council. I would like to reiterate, by no means this problem is isolated to the Northern Territory, and what is required is coordinated national approach, national action, and national uniform legislation. Thank you.
Well, it certainly does sound very complex at the moment. When we look at history, what does that tell us about the success or otherwise of federal interventions in territory matters? Because we do see that often when federal concerns are raised, there are quick calls for a federal inquiry and intervention.
That's exactly right. And these interventions erode the local vulnerable communities and erode the trust that we are building over time, and that should be built over time in coordinated way. And these issues are long-term, so we should be able to leave this land untouched in some areas for future generations, and we should be able to plan for long-term. But as you know, the Australian Constitution was drafted in 1901, and simply did not include environment protection in it.
Guzyal, really appreciate you explaining all that for us. As I mentioned, it's a complex issue and one that it sounds like will be the focus of some federal thinking over the coming weeks and months. Thanks for your time.
Thank you very much.